deal with McNeil and others and HMRC part heard.
I'm sorry it's 10:20 rather than 10:15, but then if it had been 10:30, it would have been 10:35, no doubt. So. Yes.
My Lord, good morning. Mr. Moretto, my instructor solicitor, Ms. McGann, did some work, as you requested overnight, on illustrating the point that the distribution may not, or the story on distribution may not reflect the story on averages, and that those calculations should be on your desk, if I can ask you to.
Oh, right, yes, thank you. Let's, will you talk us through them? Well, they're so simple, we don't need to be talking through them.
So you have those in front of you?
We do.
So the first one is, the first page is intended just to illustrate the simple point that distribution, which is ultimately a process of ranking, can show, or can fail to show, any particular pay problem on this example. As we submit, what is of interest though is to learn what people are paid at each level of the distribution, and of course when you find that in this particular example, you then begin to ask whether there is a problem, because what you find is that the man at the highest, in the highest quartile, let's say, is paid significantly higher, and that the average rate for the men is significantly higher than the average rate for the women. The examples then get more sophisticated if you go to page 2. Here what you've got is a grade which has a pay range £50,000 to £90,000, quartiles therefore of £10,000, and you've got 8 people in grade, and you've got an even distribution between the quartiles. So if the distribution or clustering approach is the only way to measure the question of particular disadvantage, the conclusion would be that there is no particular disadvantage in this case. If you look, however, at where...
Perhaps is what we're into. Don't we want an example where...
I'm going to come to it. The crucial point in terms of the issue in the appeal, or the central ground of appeal, is that paragraph 39 of Mr. Cooper's skeleton, reflecting the case that he put to the Employment Tribunal, was that the only logical basis for assessing particular disadvantage in a case such as this is distribution. If he's right about that, then it's the only logical basis for doing it. Then he establishes error of law on the part of the judge. If he's wrong about that, though, his appeal fails, because the case that he sought to prove by proving differential distribution. That case was analysed by the Employment Tribunal and rejected. And so part of our argument is obviously to ask the question, well, if you look solely at distribution, do you get sensible results? And so the second example shows here, if you look only at distribution, you don't get the result that there's any particular disadvantage one way or the other, because the distribution is entirely even. But if, as we contend you should, you look at what people are actually being paid on the distribution, you then discover that there is a pay problem, at least as we would submit. And that is because on these particular figures, in actual fact, the women are paid more, but you could reverse the result and the men will be paid more.
So this rises to Mr. Cooper's challenge that you, and my suggestion, I think I was more cautious than to say it was certain, that you couldn't actually get a situation.
But it's not solely, this at the moment is only making the point that if you look only at distribution, you could be misled, because you could conclude there is no particular disadvantage. Whereas if you looked at average pay, you would, in our submission, unhesitatingly conclude that there was. On these calculations to the men, but if you reverse the calculation, reverse the figures, you get the same conclusion in relation to the women. So if you go then to the next example, this is intended to show uneven distribution and potentially a result showing particular disadvantage to women, because as the figures are presented, I'm going to come back to this point, the bottom quartile is 67% female, and the top quartile is only 37% female. So on Mr. Cooper's case, you've got clustering of the women in the lowest quartile. But if you then look at where the women are within the particular quartile for each of the quartiles, and then carry out the averaging exercise, what you actually discover is that on average the women are paid more than the men.
I don't want to be difficult, Mr. Linden,
No,
but of course there would be another example of the quartile approach, which will be real as opposed to examples. Were we to look at the actual distribution of women and men in each quartile, and then we could look at the frequency and the ratio as between men and women, we might get yet a further different result.
Well, I accept that would refine the approach.
Well, it would also refine the approach by reference to the evidence in the case. What concerns me is that we're seeking to avoid the facts in the case.
Well, no, I'm not seeking to avoid them because, as I said yesterday,
we're tending to avoid.
I'm so sorry. I'm sure it's my fault.
Involves at least an intention which I don't impute.
Of course, but as my Lord knows very, very well, that the issue in this appeal is whether there was an error of law on the part of the tribunal. Right. If a party comes to court and says, look, here is as a matter of law, the only basis on which you can prove the case, and I will now prove it, and the tribunal concludes that in fact that doesn't prove the case, then the tribunal hasn't erred in law. I accept entirely my Lord's point that there might have been other ways of arguing this case which might have arrived at a different result, but typically the conclusion then would be that the employment tribunal didn't err in law and the appeal should be dismissed. But in deciding what conclusion the court will reach, obviously the court has to ask the question of principle: can it be right, as Mr. Cooper submits at paragraph 39 of his skeleton, that the only right way to do this is distribution? And what I'm pointing out is that distribution can give a misleading impression to the advantage or the disadvantage of women.
Of course, you can. The evidence based on quartiles is not the totality of the evidence, because there was also the evidence based on deciles or deciles. Which in practice, to some extent, does the job my Lord has put you, because it shows you the distribution within. It's complicated, of course. 4 doesn't divide neatly into 10, but in principle it shows you just, in some extent, the distribution within the quartiles.
So that might affect the result in the case, but it won't necessarily I'll come to that. That's Mr. Cooper's submission that there was only one right answer in this case, which is ultimately a perversity challenge against the judge's conclusion that the result produced by the distribution statistics was not significant. And what I will say about that is, well, and I'm going to show you the passage in a moment, Dr. Brown was quite clear about whether that would give you a reliable result, and the employment judge accepted his evidence as to whether the result was significant on the statistics. And that was, in my submission, a question of fact.
We simply don't know, and this really comes back to your point. And I'm banging on about a graph, but I find if we had a graph showing precise clusterings of the of all the pay points, of all the employees, that might give you a visual representation from which I think you accepted yesterday, but I can check my notes. Depending how clear it was, you could draw a reasonable conclusion. But we haven't got it, so we just don't know.
Yeah. My submission ultimately in this case is that, as the judge said, unless you can actually demonstrate a pay differential, by which we mean a difference in the average pay of the women and the average pay of the men, that is a significant difference, you can't succeed. You can repackage the data in any way that you wish, but ultimately what you've got to show is that's ultimately what we're saying or we were saying to the employment tribunal, we're saying in the appeal. But at the moment, all we have to do is to persuade you that a distribution-based approach is not the only permissible approach, and indeed we would submit, as we're submitting at the moment, would carry significant risks. I'm going to come on to the complexities potentially of that approach in due course.
Thank
So if I can just stay with the examples, you've seen for yourselves what this purports to show. There's one point of detail that I should add. You can see that Mr. Moretto in this example has looked at the number, if you take the bottom quartile where it said it's 67% female.
We're on the last page.
On the third page.
Third page.
So there are 3 people in the bottom quartile, and Mr. Moretto has recorded that in the bottom quartile is 67% female. Now, my lord, we put on your bench, I don't take you to it at this stage in the interest of time, but under the 2017 gender pay gap regulations, that is the right approach to deciding the question of distributional clustering. But as the court will appreciate, it's not Mr.
Well, hang on. Sorry.
Yeah.
You're assuming I know more than I know. Are the 2017 regulations referred to anywhere in the papers before us? I haven't.
No, I put them on your desk just
Right.
for completely so you're aware of them. But
I'm not aware of them unless you show us what I will.
okay, well, I'm happy to do.
Oh, you're about to. Sorry.
But just for your note, the approach in the 2017 regulations to a distribution analysis is simply say, well, let's take each quartile and let's ask what percentage of the employees in that quartile is female and what percentage is male, and that's what Mr. Moretto has done here. Mr. Cooper's approach is different. Who's to say which is the right approach? I'm putting it no higher than that. His approach is actually to say, well, there are 14 people in the grade. 2 of the 14 in the bottom percentile are women. So his percentage would not be 67%, it would be 28.5%. I'm going to come back to this point on complexity in due course. What is the right approach to the distribution analysis? But I'm just pointing that out at the moment for your note.
Tell me again.
Yes, that if we focus on the bottom quartile, you've got 3 people in it, and so you get the result, well, 2/3 of them are female. And that's the approach that the 2017 pay reporting regulations have.
So this is for the purposes of publishing information relating to pay.
I'm not taking any technical point that it's incorrect. I'm just drawing the point that I'm just making the point that is the recommended approach for pay reporting. Mr. Cooper's approach, which again I understand the logic of it, is not that. His is to say, well, you've got 14 people in grade, so two of the people in the lowest quartile are women, so the percentage used is 2/14, which is 28.5%. The proportion of the total number of women in the bottom grade is in the bottom quartile, is 28.5%. I'm going to come back to that because I'm going to make a submission.
I'm afraid you have lost me. Where do I find the 28.5%?
Well, it's 2/14.
And why 2/14?
Because the total number of employees in the grade is 14.
Where?
That's just above.
Oh, 14. Right. Sorry.
Two of the women in the grade, or two of the 7 women in the grade are in the bottom quartile, and therefore we get 28.5%. I completely understand why he's doing it. He's setting up what we submit as an artificial PCP case, a barrier case, and he's saying, well, the barrier is to be above the bottom 25th percentile, and he then looks at the proportion of the women who are above it and the proportion of the women who are below it, and compares that with the proportion of men. But at the moment, I'm just pointing that out because I'm going to come back to the potential complexities if the court's to say, well, employers and for that matter, those who represent employees, in this type of case, the only right way of doing this is to get into a distribution analysis, as opposed to what we would say is a perfectly straightforward way of doing it, which is to average, and as a result, to determine whether there really is a pay differential. Well,
I'm sorry, the calculation rather left me behind. Is the 28 point something percent
Yes.
2/7?
2/7.
Right, not 2 over 14.
You're right, Lord, I said I
That's,
spoken correctly.
that's where you lost me.
That's right. Well, I'm glad you were following me so closely.
So 2 of the 7 women
That's
are in
right.
the bottom.
The proportion of women
Right.
in the bottom quartile is 28.5%.
Just for completeness, can
Yes.
I be reassured that the 2017 regulations form no part of the argument for the Employment Tribunal or the Employment Appeal Tribunal. That is,
Yeah.
they were not relied upon by analogy to suggest a method that is to be used.
No, they were. I can't remember precisely on the Employment Tribunal. I think Mr. Cooper referred to them. I certainly did in the Employment Appeal Tribunal. But it's not to establish any point of law. Yes, my lord. It's simply to point out that the distribution method is not a single method that will readily be understood by all employers, trade unionists, and employees across the country, or employment tribunals who can then effectively and practically apply it.
But sorry, which bit of the 2017 regulations help you make that point?
Certainly. Should we look at those? So the pay reporting obligation is at regulation 2 if the court has those. So you've got various different, calling the phrase data points, that need to be reported. Obviously they include under A the mean hourly rate, but the one we're concerned with under F is the proportions of male and female full pay relevant employees in the lower middle, upper middle and upper quartile pay bands.
Right.
And then it says C regulation 13 as you've seen, and that's, if you've got the West Law extract, that's page 10 of the extract.
Yep.
And under Reg 13, working out the proportions involves firstly ranking, that's step 1.
Yeah.
Dividing into 4 sections, that's step 2. And then step 3, the proportion of male full-time employees within the quartile pay band must be expressed as a percentage of the full paid employees within that band.
Yeah. Yeah. Yes, exactly. The elaborate details are just mechanical. The point is.
The point is only that there are different views on what the distribution method entails. But my lord, the 4th page prepared by my instructing solicitor, Ms. McGann, is another example of how you can have a clear position, or what appears to be a clear position in relation to distribution. This time showing that 9 out of 14 men are in the top 50% and 5 out of 14 are in the top 25% in terms of pay.
So sorry, where are we now?
The 4th page of the extract that I handed up. So this is another example of how the distribution figures can tell one story, the mean figures tell a different one, and the document speaks for itself. So you have the men clustered in the top 50% or the top 25% as the case may be.
The reason why it's happening is that the quartiles are of pay, but the numbers in them are not consistent.
The 5 men are at the bottom of each quartile. The 2 women are at in the case of the 25th percent.
But the total numbers in the quartile is an important point as well.
Yeah.
It's easy to slip, I'm sure you won't, it's easy to slip into thinking that the pay quartiles are the same as the 25% of the band are in each pay quartile. That doesn't follow at all.
It doesn't necessarily follow. It depends on which approach you're taking. So in this case, 5 out of 14, that's 35% of the men are in the top quartile for pay. 2 out of 14 of the women are. That will then give you a percentage to compare. But if you leave out pay, what they're actually being paid, you get a misleading picture, we would submit. our submission is that these calculations, by way of example, at least begin to highlight the point that the clustering approach is less reliable because it may give the appearance of there being no pay problem when most people would say there is one. And it may give the appearance of there being a pay problem when most people will say there isn't. And we do submit that is because the clustering or distribution approach only provides an approximation of what people are being paid rather than asking directly whether women are actually paid less than men.
Say it again.
Well, the clustering approach or distribution approach only provides an approximation of what people are being paid. Because rather than saying, well, let's look at their actual pay values, what's being said is let's place their pay rates within a range of 25% or 10%, as the case may be. So you don't look directly.
Yeah. Okay, sorry, it comes back. When you say the clustering approach, you mean the clustering approach by quartile or indeed by decile?
Or by even, what
A clustering approach by graph wouldn't have that problem because every point would be shown.
Yes, but my point remains that that would be again be an unreliable approach to simply, as I accepted yesterday, there may be a graph that produces a result that's so stark that you don't need to go on to ask whether there's actually a pay differential. There probably obviously is. But my submission is that in every case, you need to establish a pay differential.
No, I can see a
any
graph.
live person
You
would
may
ask,
make.
is there a pay differential?
Yeah.
In other words, can I take you to, in the supplemental bundle, to what Dr. Brown was saying on this subject to pick up some points made by...
I'm sorry, I'm just trying to get one. Quite difficult to devise a graph, actually, wouldn't it? Because if you just show the pay points, you don't show the numbers in the pay points. And if you just show every... Well, I'm not quite sure what a graph would look like, actually. Maybe like one was produced.
It could be a huge scatter graph, because of course we're talking about 1,200 employees in the case of grade 6, and I think 2,300.
Yes, but if you had 300 of a particular pay point, how would you show that in a way that showed the weight? Yeah.
Well, can we go to what Dr. Brown was saying, which is we can see in a fairly short passage from his first report. That's in the supplemental bundle at page 188. If we start with 188, and I'm going to come back to the chi-square test in some more detail in a moment. What was being said at paragraph 18 is that as base pay, the base pay variable is not categorical, the chi-square test is not appropriate. Transforming base pay variable into categorical data reduces a large number of observed salaries and effectively throws away the wealth of information contained in the original variable, as differences within quartiles, which the values of base pay distinguished are ignored, as each member of staff is simply counted. So you then, next point, to interpret the results of chi-squared base pay, which can only be the proportions of staff within quartiles is not in the context, requires a test of what these different proportions mean in practice in terms of the target variable for base pay. The quartiles interpret, as you can see, in quartiles but without associated numbers, these are meaningless. Simple averages could be taken within each quartile to aid comparison. These would ignore the actual numbers of staff in each quartile contributing to these averages. So total pay could be calculated in each quartile, summed over quartiles, then divided by the total number of staff. But then the analysis comes full circle. So what Dr. Brown as a statistician was saying was that the problem with imposing what are ultimately notional categories on continuous pay data was that you were essentially repackaging the data at a higher level of generality than you needed to or ought to, and as a result potentially producing an unreliable picture. Now, Rod, as far as the chi-squared test is concerned, you said to Mr. Cooper, and he agreed, well, you didn't really need the chi-squared test in this case. That wasn't really the position before the Employment Tribunal. It was Ms. Hall who introduced the chi-squared test because she recognised that you needed to have a statistical test of significance, because otherwise you're simply making a crude visual assessment of the data now grouped into quantiles or decils. And so she advocated the chi-squared test and performed the chi-squared test as a way of demonstrating that it was indeed a significant result. So she clearly recognised that it was necessary to have a test of significance, and it certainly wasn't Mr. Cooper's position for the Employment Tribunal that he didn't need to have any test of the significance of the distribution data. And it would have been surprising if that was his position, because as I've illustrated, the distribution data doesn't necessarily tell you a reliable story unless you can apply a test to find out whether it is.
That isn't the kind of test that chi-square is it? That chi-square isn't intended to test significance in that sense.
Well,
It's intended to test something quite different, which is whether the results are other than you would expect by randomly as a result of chance.
yes, but that is in as I understand it, what significance is. That are you getting a result that's meaningful, or are you getting a result that's not actually telling you anything other than?
Well, I think we have to be careful about this. The term
Yes,
statistical significance, I have always understood to mean, but I could be wrong, only is it different from what you would expect by chance. In a lay sense, statistics may not be significant in a rather wider sense. Most obviously that the statistics don't allow you to draw any conclusions from them because of confounding factors. Other features in the ultimate, you're normally talking about causation, not always, but you're trying to draw a conclusion, and there may be other factors which the figures don't test. Now that you could call also are they significant?
Yes.
And when I've always thought that when in Enderby they talk about are the figures significant, they are meaning it in that wider sense.
Well, are they indicating that women underlined are being placed at a particular disadvantage
Yes.
by the impugned factor?
You see things like the point that you made yesterday, that women may be being moved out of, maybe being promoted faster out of the grade because of all sorts of reasons there.
Yeah.
That isn't captured by these statistics, so in that sense you could say they're not significant. In the sense they don't reliably show what you are trying to find out. But chi-square is only intended to show it's just where things fall by chance.
Yes.
I could be, please don't, I'm not lecturing you as if I know, but like all of us, I've had experience of this in other contexts, and that's what I've learnt, and if it's wrong, you must tell me.
If I can put it this way, that's what I understood as well, that it was being said, well, the chi-square test tells you it's not an arbitrary or random result.
Yeah.
But Dr. Brown was objecting that the chi-square test was only appropriate when you're assessing what he was calling categorical data.
Yes, quite.
How many men and how many women get a particular discrete allowance? How many drive a red car as opposed to a white? And that's the point that he was. That's the point that he was addressing at page 187, and saying that it's simply not the appropriate test to apply in relation to continuous data, which is what you're concerned with here, more than 100 rates of pay in a given pay grade. Well, that's all I wanted to say in relation to that section. Can I turn then to the Equality Act, which we can take relatively quickly as given time, but also as Mr. Cooper has obviously shown you the legislation and you're familiar with it. But the Equality Act is, well, the extracts at tab 2. Lords, there are 2 points of construction of the Act that we make. The first is that we do submit that the legislation operates on the basis of a comparison of contractual terms, including where the issue is particular disadvantage. And secondly, we point out that the comparison has to be a comparison of what they are actually paid, which we submit points to our analysis being correct. The comparison that's required is not a comparison of where they might be on a particular grade. It requires asking what are they being paid? Is it more or less favourable? Is the approach disadvantageous in terms of what they are paid? Well, as to point us to that construction being correct, as we suggest it is, I just remind you of section 65(2)(b). The different concepts of equal work include, in relation to like work, the question, firstly, whether the work is the same or broadly similar, but secondly, where differences in the work are relied on. The question of their, dare I say it, significance or materiality is to be answered by reference to the question whether, this is under 2b, whether the differences between their work are not of practical importance in relation to the terms of their work. Well, section 66 you've seen, and Mr. Cooper appears to accept this, requires that at least at the stage where the complaint is of less favourable treatment, the less favourable treatment has to be different treatment as to the terms of the claimant's contract compared with the terms of the comparator's contract. My Lords, if you go then to section 70, there was reference to the historic position that the legislation, for reasons which are not always easy to understand, the legislation started with the Equal Pay Act 1970 alongside the Sex Discrimination Act 1975. Those 2 regimes are preserved in the legislation. The modern provision, as it were, differentiating between the types of case is section 70 and 71, with which I imagine the court is familiar, but essentially section 70 and 71 provide that if the complaint is about sex discrimination in relation to terms of the contract, that's section 70 subsection 1, then it must be dealt with under this section of the Equality Act. If the complaint is as to the treatment of the claimant by the employer, then it must be dealt with under the equal treatment provisions, and most relevantly here, employment section 39(2). So section 70 is building in a clear distinction which identifies that this part of the Act is concerned with discrimination in relation to the terms of the contract. I mention in passing section 71, that then, it's really a footnote point, but that then carves out cases of direct discrimination where the individual is complaining of direct discrimination in relation to pay but is not able to identify an actual comparator. Well, there's a case on that, BMC Software, 2017 IRLR 1074.
Sorry, 2017 IRLR
1074. If we then look at the authorities looked at by...
I've been slow.
Yep.
What is section 71 for? I've not had to look at it.
You're not being slow, it's not crystal clear. What section 71 is saying, also the explanatory notes of the BMI case tell us, is that if you've got a direct sex discrimination case and the complaint is about pay, then if no comparator can be identified, you won't be able to bring the claim under the equal pay provisions, and you may then bring the complaint under the equal treatment provisions. So you can rely on a hypothetical comparator for direct discrimination cases.
Oh, I see. So this is another consequence of what I was moaning about yesterday, that you set up a separate regime for pay under the 2010 Act, reflecting the mechanisms of the 1970 Act.
Yeah.
And one of those mechanisms in the 1970 Act was that you always had to be able to point to a person. There are cases where you may have a good case for sex discrimination, say, even though you can't point to a man filling any of those gaps. And that's always been regarded as one of the failings of the 1970 system. So they
modified it for direct discrimination cases.
Right.
Last statutory provision, section 132, again, we don't need to spend too much time on it, but in terms of remedy...
132?
Section 132, which I put on your desk at In terms of remedy, there's a long history to this, as the court will know, but the upshot of it is that the question of remedy is approached as you would expect, on the basis that the complaint is a breach of contract. So
Yeah.
If you can look at the case law, we don't need to go back to Hayward and Camel Laird. I just need to pick up points made in relation to Bramble by Mr. Cooper. Bramble's at tab 19, if you wouldn't mind looking at that. Ultimately, I just want to make 3 points. That Bramble, like Hayward and Camel Laird,
This is the first point.
reflects the policy of adopting ultimately a pragmatic approach, in the sense that it seeks to avoid complex arguments in relation to the comparisons that are sought to be made. Secondly, it illustrates, as some would say, Hayward and Camel Laird illustrates, that may then have some rough and ready results. In Hayward and Camel Laird, the employer wasn't permitted, at least at the comparison stage, to say, well, but if you look at their other terms, the overall package is more valuable. In that connection, if I can just remind you of paragraphs 3 to 5 at page 71, the position, as you recall in Bramble, was that the women's underlying hourly rates were higher than those of the men, but the multiples applied to those rates for antisocial hours working were lower. And the question was, can they say, well, it's all very well, I do get paid a higher hourly rate, but the multiple that should be applied, I can make a comparison based on the multiple that's being applied. And the Court of Appeal's answer was, yes, you can. And that was, despite the fact, if you look at paragraph 5, the basic hourly rate applicable to the claimants, which differed as between claimants, was in all cases higher than that applicable to the male comparators. This is why, with one exception, the claimants actually received more than the male comparators. Now, that is the law, but both sides are crying foul on the basis of distortion or surprising results and so on. My submission is, it's true. the pragmatic approach, which seeks to make the legislation effective and comprehensible, does sometimes mean that a broad approach has to be taken, where some could see it as ultimately not fair to them. Now, the third point is in relation to Mr. Cooper's analysis of Degnan. He wasn't explicit about it, but he appeared to be wanting to submit that even at the initial comparison stage, it wasn't necessarily the case that you look at the contractual terms as to pay. That was it. I'm not sure precisely what he was submitting, but that appeared to be the references to reality and the time that we spent looking at what the court said about Degnan. But if you look at paragraph, page 74, page 16, sorry, page 74, paragraph 15, the position in the Degnan case was that the men's pay was a basic rate for working ordinary hours, plus an attendance rate for working ordinary hours. And the way that the Court of Appeal explained, and it's Morris Kay and Royal Justice Morris Kay in Degnan as well, explained the decision that had been taken in Degnan was that the circumstances included the fact that when the men's terms had been negotiated, there'd been a history of bargaining devices and artefacts that tended to conceal the reality of the pay elements. So in other words, rather than say, well, we will pay you a higher basic rate, they were saying, we won't increase your basic rate, but we'll pay you an attendance allowance for exactly the same work, as a way of ultimately disguising the reality of what was going on. Now, in my submission, that's a long way from the position in the current case, where there is no suggestion, and nor was there any suggestion before the Employment Tribunal, that there is any reality to the suggestion that pay decisions are made by reference to levels above a minimum rate, or that there was any term which incorporated the ranges. The case was argued below, and is indeed, as I understand, argued before you, that the only term with which we're concerned is the term as the basic rate of pay. That was the complaint below, and that's the complaint here. And in my submission, the artifice would be then to identify a notional part of the basic rate, which could then be examined in terms of how it varied according to length of service. Can we then, with that go back into section?
Yeah, I mean, there's another way of putting it, that simply the relevant contractual right is simply the right to be paid X on each payday.
That's right. And Mr. Googin
Relevant contractual term, perhaps I should say, but to use the language of the Act, the relevant contractual term is that in any year, the contract varies each year, but that in any year you will be paid this amount on each payday.
That's right. And that was only contractual term that sought to be established. Mr. Cooper's skeleton, although less so in oral argument, sought to suggest that there was a contractual term as to minimum pay and so on. That was no part of his case below. He wasn't really arguing it orally, but very fairly he was accepting that the only term that's ever been an issue is the actual basic rate of pay. Now, if we then go back into the 2010 Act and look at section 69,
It would be different, wouldn't it? But this isn't a problem for you if there was a contractual right to pay progression. If there were a contractual right to pay progression.
yes, then you'd have different.
If, as you, in some old-fashioned public sector contracts, you used to get and probably still do get, it actually says yeah, you will move 1 point up. Well, I wonder about that actually, because the trouble is the points aren't
The
identified.
terms would be the same for the men and the women.
Yes. Yes. Okay. Ignore that.
Tab. So if we go back to tab 2 and look at section 69, you've seen obviously that the section starts 69.1 with reference back to the fact that the problem that's been identified is a difference between A's terms and B's terms. And the question then is, can the employer provide a non-discriminatory explanation? And on direct discrimination, the question is again, well, she gets less favourable terms than he gets. Is the reason?
Sorry, I was just writing a note. Where are we?
So we're at section 69,
Yep.
tab 2. On the direct discrimination type of case, the question is, why are her terms less favourable than his? And if the answer is because she's female, then the direct discrimination case succeeds, and that is subsection A. And in our submission, the approach to particular disadvantage is the same. That the question is the factor resulting in a particular disadvantage to women in terms of what they're paid? Mr. Cooper is attempting to say, well, that's not the question you should be examining. The question you should be examining is not by reference to the actual basic pay term, but by reference to a notional component of the basic pay term, and we submit that's simply wrong as a matter of construction. Particular disadvantage is not in our submission established unless you can show that the factor results in women being paid less.
It could be argued, Mr. Linden, that the agreed facts don't actually explain this court, let alone those who might have been more persons below, precisely how, in the absence of spinal points, length of service actually works in these two grades. One can speculate how it does. It excludes performance and any other relatively extraneous factor. I'm not entirely sure how it works in practice. You need to look at the pay settlements in each year and the narrative relating to those pay settlements to actually understand it. And it's obviously not formed a part of the litigation.
Well, that's partly because of one of the difficulties was that the data about length of service in grade was incomplete, so it wasn't possible to do a comprehensive statistical analysis of the effect of service on pay.
Yeah.
What therefore the process in which we were therefore engaged was to look at the evidence and ask whether it could be inferred from the statistical case and the other evidence that the pay system was the element of the pay system, which was annual pay reviews, was causing women to be paid less. And that's my point about Enderby versus a PCP type of case,
Yes.
which I'll come to.
But just to explore my lord's point a little further, the whole point of having it is meaningless to have a grade with a minimum and a maximum unless there is implicit in it some notion of progression, because otherwise a grade has no content. I mean, a grade in a different sense, if you have a grade where you're paid X, the purpose of the grade is simply to show what your pay point is. But a grade of this kind, which is in fact a pay band, perhaps that's a better way of putting it, the whole point of a pay band is that there is the possibility of moving up through it. Is that right?
The possibility. I mean, obviously subject to performance.
Well, yeah, subject to performance. And I think you say possibly, and in practice, the expectation that subject to performance you will move up through it, because otherwise, what is the point of a band?
Well, I see the point, but and I'm not saying this is the present case, but the point of a band may simply be to establish the maximum anyone whose work has been rated as falling within this band can be paid.
But why would,
The
on what basis would you be paid more, or be paid one point in the band rather than another point in the band?
There are pay systems where you have a band, and the job is then evaluated and placed at a band, and a rate of pay is then decided by reference to market factors or what they were being paid in their previous and so on. And I agree that under that system, the expectation is that they'll progress, because especially if assessment is on the basis of performance, if they go 10 years with no pay increase because they've performed badly, the expectation is that they won't still be there. I'm not sure we'd necessarily disagree.
We need to understand, because the appeal is open to us, and you may not, of course, agree with the way it's opened, as a length of service and or time progression point. If it isn't a length of service, time served point, and it is a particular person's evaluation stroke performance within a band, I think we have to be clear about that, because I appreciate we're straying, you may say, we're straying into justification issues, and you may want to hold your counsel in relation to those issues. But actually, what is the point that influences the distribution, if it is not male-female ratios, is important to the very essence of this appeal. And as it's not part of the agreed facts, we either do or do not know about it and have to draw our own conclusions.
Well, I hope I can answer that question by saying that the parties did not disagree. Well, the parties agreed, just as a matter of logic, that under a system where in each year there's a pay review, then provided the pay review is intended to result in a pay increase, the more years you're there, the more opportunities you have for a pay increase.
I wonder whether that's right, because if the minimum and the maximum go up, and you only go up relative. Suppose in any year the minimum goes up by 2%, the maximum goes up by 2%, and everyone in it goes up by 2%. That's not what most people would understand as pay progression.
Yeah. Well, the way it worked was there would be a decision about the maximum and the minimum, which tended to be that the minimum would be going up because there was a policy of pay of
Yes, right.
There'd also be a decision about the individual pay increase. So there were two percentage increases in play.
Right.
And the individual one was, as you've read, on the basis of performance, and I accept that in general people's pay did increase on the basis of performance.
But did it increase relative to the increase? Did it increase more than the increase in the minimum?
The answer to that is yes.
Yes, that's what I thought. So that although it was slowed down, maybe in some years even halted by exceptional austerity provisions, the basic pattern is that people whose performance was good enough, which was nearly everyone, moved up relatively within the band, relatively to the minimum, but not as fast as you might have expected for all sorts of reasons, and not at a fixed rate, as it would be the case if there were spinal points.
Those who were at the maximum depended on the maximum being increased to get any pay increase.
Yes. But it follows from what you said is that people who were at the minimum would gradually, by uncertain steps, and possibly different in different years, move up towards the maximum.
Yes.
Yeah. But it's much fuzzier. I know we've all made this point, but it's much fuzzier than in a case where there are 5 steps within the band, and you within the band, and you go up year by year unless you perform badly.
Yes.
So there are two separate pay awards for each individual, are there, Mr. Linden?
It depends. If they were on the minimum, then they would go up with the minimum and get an additional. It varied from year to year. Different approaches are taken in different years. That's
Yeah, but in terms of the expectation inherent in a band, to stick with, I mean, as what happened historically, which, if we ever get there, would have to be considered in the context of the issues about justification. But unless there's no idea of pay progression in the bands at all, the concept must be that as long as you perform well enough, you will have a pay increase larger than the pay increase at the minimum. Because otherwise you're standing still within the band, not progressing within it.
I'd need to think about that.
It's quite important.
My lord must be right, because unless the
I'm getting nods there, but I'm getting room to the ears well.
I'm right.
Pleased to hear
Even
that.
more quick thinking people than me behind me.
But I'm probably being slow here, Mr. Linden, but the agreed facts seem to indicate that, put it in very broad terms, everyone gets the same performance-related increase, apart from the people who are graded poor, who don't get a pay increase. So 2 points seem to me to arise from that. The first is that just as more years of service equals more opportunities to get a pay increase, it also equals more opportunities to fail to get a pay increase by returning poor performance. But doesn't it also mean that once you've started, subject to performing poorly, you're in the same position as everybody else? Because as I read the agreed facts, everyone's going to get the performance-related increase.
Yeah.
There are 4 grades, and the top 3 of them all result in the same increase.
Yeah.
The only one that's different is the poor performer.
Apart from those who are at the maximum, those who are at the maximum, in some years they decided to increase the maximum, so they got a pay increase. In some years they didn't.
Yes.
Right.
But I think I'm sorry to keep campaigning on it, and the people behind you are not sure.
Right.
Mr. Moretto, I think, is helpful. That the way it is meant to work conceptually and subject to problems in particular years is that the longer you are there, the greater chance you have of moving up within the band, i.e. relative to the minimum, until you hit the maximum.
Yeah.
Otherwise, there's really, as I said, there's no content in the band.
Yeah.
So with all sorts of footnotes and other points that had to be explored at the justification stage, there is content in Mr. Cooper's point about the longer you're there, the greater the opportunity you have to progress within the band.
And that's never been in dispute.
No, I
What's
thought
been
not.
in dispute is whether that feature of the pay system put women at a particular
Absolutely. But at least we've got, but I think my lords, with respect, are right. If you look at the agreed statement of facts, all this is really sort of taken for granted.
Yes.
And it needs to be spelt out. Yeah, thanks.
So to make it plain, this is a band within which, subject to any differential pay award in a particular year, one moves towards the ceiling by performance. And that is how length of service is relevant.
That's right.
Full stop.
Yes, with differences in starting point according to
Yes.
the history.
I entirely accept that.
And with this, perhaps, it may not ultimately matter, but by performance it would be rude to those behind you, is a little bit artificial. It's true you can be held back by poor performance, but as long as you do your job well enough, then you have performed well, and then you get the money,
Yeah.
you get the increase.
I'm not pretending to you
No.
that it was part of our case that
No.
the performance criterion was having a major impact on
No,
pay.
exactly.
Because the evidence before the tribunal was that most people got a performance-based.
Yeah.
Thank you. Well, I think that's been useful to bottom that out because it's actually essential to the case and doesn't perhaps sufficiently come out.
I'd say that was my section on the Equality Act and the case law about that. The point is that I sought to derive, well, firstly, that the concern is from start to finish about a comparison of the terms of the contract complained about, rather than subdivisions of terms, notional or otherwise. And secondly, in the context of the present case, since the term complained of was basic pay, my submission is that the legislation therefore points to a comparison of what people were being paid, a direct comparison of what they're being paid, as opposed to an indirect comparison by putting their pay rates within broad ranges of 25% or 10%. Can I turn then to the code and take that briefly? That's tab 4. My lords, you've got in tab 1, you've got section 15.4 of the Equality Act 2006, which says that the code should be taken into account where relevant. Mr. Cooper and I agree that it is relevant. My submission in relation to the code goes no further than to submit that the approach advocated by the Equality and Human Rights Commission is entirely consistent with the approach that we're advocating in this case. And indeed, as you've seen, Dr. Brown was basically saying he thought that was a sensible way to deciding whether women were placed at a particular disadvantage in relation to pay. And what you've seen, if you've got at step 3, para 177, is essentially the division that we've touched on between continuous data and categorical data. That where what the employer is preparing is information to identify any significant inequalities in relation to basic pay by comparing average basic pay and total earnings, and in relation to discrete elements of the pay package, the categorical approach that you've seen Mr. Cooper is attempting to impose on the present case. And there is then further guidance at 178 as to calculating average basic pay, and then I would submit the reference to the toolkit at page para 179 again indicates guidance to the parties to this type of dispute, but in particular to employers carrying out equal pay audits, which should be taken into account by the court as being relevant to the legal issue in this appeal. So it gives detailed advice and guidance on collecting and comparing pay information and when pay gaps may be regarded as significant. The toolkit you then have at tab 4 if you take up page 102 under analysing pay, again I don't read it out, but it's the same point as is made in paragraph 177 of the code. And if you go then to page 109, again I don't propose to read it, but that's the material dealing with when a red flag should be seen as having been raised by reference to the 5% or the 3% if persistent patterns of pay gap.
Can I just, red blur, the percentage is right. Yes, we won't refer to this, I see, but it's 5% or more, or 3% or more if there's a pattern.
And it's saying the red flags because it's all about an auditing process, and that's what requires you then to investigate further. So I don't suggest, well, you can only win if it's 5% or more, you can only win if it's persistently 3% or more. I don't suggest that this is a definitive account. I say no more than, again, that the Equality and Human Rights Commission is clearly advocating, in relation to basic pay at least, the averaging approach that we're contending for. And that isn't surprising to us, it was a matter of common sense. Most people would be interested to know whether there is a pay differential where the complaint is about basic pay. As far as other
I know exactly what you're going to say to this, but I want to just, well, perhaps I don't know exactly what you're going to say to it. The figures, the mean figures we have, show differences between 1% and 3%. And I do know you're going to say that is not the way the case is put or has ever been put. And I have got that very much on board. But we need to think about principles and what guidance we may or may not choose to give beyond the facts of this case. If the case had been put that way, and said, well, look, there is a persistent pattern over many years of less than 3%, and there are reasons to believe, maybe not using distribution analysis, maybe simply using the facts of the case that women have come in more recent, there's been differential recruitment. Would it be legitimate, would it be open to a tribunal to make a finding of indirect discrimination on the basis of the sorts of percentage figures we see here?
It would depend on the most important question is what pay differential, if any, is being caused by the impugned factor.
In a way,
And so, if it was clear on the evidence that the impugned factor was consistently causing a material pay differential, so what is material is for the employment tribunal to judge, then the claimant will win. Now, as to that's the point here, that you've got the percentages, the percentage pay differential, but as to precisely what part of that differential was caused by the impugned factor, that was in dispute, the materiality of the impact of that factor on the pay data that you could see.
Would this be a fair summary of your position, that subject always to the caveat, this is never the case that's been put, these figures might, even though the percentages seem very small, in principle, have justified a finding of unequal pay? You referred yesterday to Ches as meaning subject to de minimis, small differentials, yes, to be material, but that there would then have to be an analysis, which there never was or has been, as to the extent to which those figures around between 1% and 3% were in fact all due to the factor.
Exactly. And I point this out, although you're aware of it. I'm accepting, therefore, that if it was clear that the factor had caused those differences in average pay and was the sole cause, then it would not. I couldn't make it appeal on grounds of perversity if the employment tribunal said, well, that is a particular disadvantage. But of course, we were also arguing that the gap is narrowing, it's not persistent, and so on, and therefore arguing a counterfactual case.
Okay, thank you. Sorry to go back to that. Whenever we look at these percentage figures, it makes me think.
So you've got then at page 105 the passages relied on by Mr. Cooper, paragraph 3.6, and his submission is that his approach is entirely consistent with paragraph 3.6. That paragraph 3.6, as you recall, is about the categorical case where you've got a particular element of pay. The question is are those who are entitled to it disproportionately male, so there's a particular disadvantage to women, and the EHRC is saying, well, then the chi-squared test would be appropriate. That's entirely consistent with Dr. Brown's evidence. He was saying, yes, if we were concerned with categorical data, then that would be the approach. And indeed, if we were concerned with a case of a provision criterion or practice that affected access to a particular allowance, then that would be the right approach. But our point is, and Dr. Brown's point is, that that's not what this case is about. This case is about continuous data. And so there's an artificial transformation of the data in order to arrive at an artificial position that you've got categories of pay, and then to apply the chi-squared approach to establish your differential distribution. Well, there's further material on that of the detail which I don't trouble you with on at page 110.
That I think answers, sorry to interrupt, the point that arose yesterday in relation to Lady Hale's use of language. When she was distinguishing between causes and correlatives,
Yes.
you would say that she must have had in mind categorical data and not continuous data, because you can't get into that analysis on your case without understanding what is real pay data as opposed to something which is artifactually altered by the methodology of comparison.
My Lord's question may be based on a superior understanding of statistics to mine, so I won't necessarily, I won't answer it yes or no. Can I just at page 110, you've got further on that topic. Again, I don't trouble you with the detail of it at this stage, no doubt you'll go back to it. And then if you've got page 122, you've then got material on pay progression. Again, I don't take you through all of it, but you've got the heading, how do you find out if there's a problem? You should check that men, white and ethnic minority employees, disabled and of differing age groups and contractual status will be with comparable length of service and doing equal work, or in the same grade or band receive equal average pay. If one of those groups clusters at a particular pay point to other comparable groups, you need to investigate why that is. Now, Mr. Cooper sought to rely on that certainly before the Employment Appeals Tribunal. What I point out is that the starting point, and in our submission, the finishing point, is always that a pay differential in relation to average pay has been established, and the reference to looking at clustering assumes that that is the position. There's further material that is relevant at page 138. Just above the first whole part, the heading long pay scales or ranges, and the risks inherent in that approach to pay. And under the heading, what are the risks? Again, passages that Mr. Cooper relied on below, and may in due course rely in this court. What I point out is that if you go over the page to how you identify the risks, the step one is always to calculate the average male and female basic pay. So my point about that then is that all of the references to clustering in the toolkit are on the assumption that the clustering reflects differences in average pay. And so,
you say the toolkit, in each example that it uses, the toolkit directs you back to averaging basic pay if you've identified a cluster and therefore in effect a prima facie problem.
Yes, and that is because, as we would submit, if you can't win on average pay, in other words, you haven't established what we coin a pay differential between women and men, or a significant pay differential between women and men, then in our submission you can't win. And what's happened in this case, as we would characterise it, is Mr. Cooper started off thinking that he could, this was the explanation he gave to the Employment Appeals Tribunal, thinking that at the beginning of the case that he could win on the basis of pay averages, appreciated that that wasn't necessarily the position, and so through the distribution analysis has repackaged essentially the same data at a higher level of generality than the specific pay points. And sort of say, well, if you look at it in a more general terms, then in fact there is a pay problem. And our submission is that the distribution analysis doesn't therefore add anything. If you don't win on the averages, you don't win. If you win on the averages, you don't need the distribution analysis.
And you say that's the effect of Dr. Brown's evidence that you took as a supplementary 1A.
That's right.
Namely, whichever way round you look at this, you still need the averaging material because that's the only real data analysis.
You have to establish a pay differential.
Generalisations.
And that's not to say that there's no point in looking at clustering at any stage in the analysis. I accepted yesterday and still accept that if you notice that there appears to be clustering, then you should go on and investigate whether that reflects a differential in average, a pay differential as we've characterised it. But what you can't do is say, well, I accept that I can't establish a significant pay differential, but if I examine the data at a higher level of generality, then there does seem to be a problem, and therefore I can win. Well, can I then turn to a section commending our approach and the approach of the EHRC, which is an unusual position for the employer to adopt in these types of cases. But I do make the point that I do reiterate the point that there's a level of pragmatism inherent in this part of the legislation, and that is because the legislation needs to be effective rather than producing on a regular basis silts arguing statistical cases which they barely understand before the Court of Appeal.
We don't understand them at all.
So I do say that Mr. Cooper's proposition of law that the only approach is a distribution approach gives rise to the potential for increasingly complex statistical arguments. And if I can just highlight some of the points that I would make. I mean, firstly, there is no single correct, in inverted commas, approach to the distribution analysis in this type of case, whatever that means. As you've seen by reference to the 2017 regulations, the question of distributional clustering under those regulations doesn't involve the same approach as the approach taken by Mr. Cooper. Other approaches that employers sometimes use is simply to rank the men and the women and then to compare the rates of pay of the woman at the 25th percentile with the man at the 25th percentile and so on. Again, that's a distribution analysis. There's no correct approach to dividing up the range in the way that Mr. Cooper has done it. It could be quartiles, it could be deciles, it could be thirds, it could be 20th percentiles, and the results or the picture created might be different according to which approach you took. Next question, when is the result significant? And you've seen that the parties fell to arguing in this case about whether the chi-squared test was an appropriate test of statistical significance, with independent experts on both sides arguing statistical cases. Well, those in my submission are perfectly obvious reasons why the legislation can't have intended that Mr. Cooper's approach is the only right approach. But in addition to that, one asks the question, well, what if the result is not clear on distribution? So you might be that if you divide the workforce into 20th, into fifths, or the pay range into fifths, you get one result, quartiles another, deciles another. You might, as we saw in the examples that I put before you in the morning, earlier this morning, get a lumpy result, if I can put it in those terms, that women are concentrated between the 50th and the 76th percentiles and the men at either end, or you might have women in the top and the bottom quartiles and so on. Mr. Cooper's answer has to be, well, the claim fails if there isn't, if you look at the picture created by the distribution and you don't see in it a clear result of women being disadvantaged, the claim fails. But in my submission, as you know, whatever the distribution result, you would always, in my submission, for the reasons that I've sought to identify, want to understand what the burden was in terms of the actual pay differential. That is, in our submission, the critical question in this type of case. And I would make that submission even where the result on the distribution analysis appears clear, for the reasons that I sought to have answered at the beginning of my submissions this morning at least. You want to check whether what appears to be a problem really is a problem. Lastly, in terms of the practicalities aspect, what if the distribution result is clear one way and the averaging result is clear another? What then? Mr. Cooper's answer is you have to go with the distribution result because that's the only logical way of answering the question. Can I then turn to how justification works on Mr. Cooper's analysis? Here my submission is that Mr. Cooper is attempting to run with the hare and the hounds, in that he now says, well, actually you can then bring in the extent or otherwise of the pay differential. Our position is that we agree, obviously this is what the legislation says, that the factor which has been identified, you have to examine the factor which has been identified as causing the group disadvantage, and you have to ask whether it serves legitimate aims and is a proportionate means of achieving that aim. So you do have to justify the factor. But as you also saw, this is Homer paragraph 24, that involves balancing the group disadvantage with the aims pursued by the employer, the employer's interests. Now, if the position is that the group disadvantage is a disadvantage in terms of distribution on a pay scale, then the right approach to justification in our submission, applying paragraph 24 Homer, is to attempt to balance that against the interests that the employer is seeking to pursue, the legitimate aims. But that is Mr. Cooper's keen on logic. That is the logical position, because that's the group. That is the relevant group disadvantage on this case. But he recognises, obviously, that that's inherently problematic, because you're then trying to balance an abstraction against the aims of the employer. It is only, as we would submit, when you then introduce the values, the actual value, the actual pay values, and calculate the actual pay differential, that you're in a position to carry out a meaningful balancing exercise as between the group disadvantage and the aims of the employer. Now, Mr. Cooper accepts that, no doubt for pragmatic reasons, because he recognises that the approach to justification would be impossible if you were seeking to balance an abstraction against the reality of the employer's aims. And he recognises that employment tribunals will want to know, well, what does this actually turn into in terms of pounds, shillings and pence? What is the pay differential that is caused by this particular factor? Is that proportionate when one considers the employer's aims? But that's where, in my submission, he adopts pragmatism rather than logic, because one asks the question, well, if you're not entitled to look at averaging for the purposes of particular disadvantage, or only entitled to look at distribution, why, when you then consider the impact of that particular disadvantage weighed against the employer's interests, all of a sudden you are entitled to look at the averaging, and that is the most, he's quite right, that is the most important consideration.
Well, do you go further than in fact you have to at that point, because there isn't any alternative mechanism available?
Yeah. Well, our case is that from start to finish you're interested in the pay differential that is adverse to women, and you're asking, you then have to balance the pay differential against the employer's interest. Your approach is causing this difference in pay, and is it therefore proportional or not?
I know it's a matter for Mr. Cooper to come back to if he chooses to.
Yes.
I'm trying to conceive of what alternative balance might be. And you flagged up there that actually, if you're looking at a differential, it has to be real. Distribution doesn't work when you come to justification. It has to be real.
So yes, exactly. So if it has to be real at this stage, why does it not have to be real at the particular disadvantage stage? Our opposition has to be real from start to finish. That's our position on justification. And of course, you then ask the question, well, what is the position if on Mr. Cooper's case, if the particular disadvantage is indeed established, it's stark at the particular disadvantage stage, but then on justification, when the averages are then brought in, it becomes apparent that the men are paid more on average than the women. What is the tribunal supposed to do at that stage? If the answer is, well, it's to say, well, actually, it's obviously justified because it doesn't cause, it's obviously justified, that must be because the tribunal's recognising that it doesn't actually cause a particular disadvantage to women in terms of their pay, and that's why it's justified. So our submission is that the pragmatic acceptance that you bring the averages back in at this stage shows up a fundamental flaw in Mr. Cooper's argument and brings you back to the strength of our position, which is that you're always interested in what people are being paid. Can I then turn under...
Sorry to interrupt you again, but then just to take your argument to its logical conclusion and refer it back to Mr. Cooper's, you say that for all its limitations, averaging as the only cross-check against what you find in clustering allows you to come to a conclusion about likelihood of disadvantage, which doesn't fall into the trap of measuring value. It is still showing frequency of disadvantage because of what averaging is.
Yes. Because that averaging is essentially asking whether somebody above the line has been cancelled out by somebody below.
Yeah.
I then heading in my notes, Grundy, Allenby and Pike. Sounds like the beginning of a joke, but it isn't. I can take the, or a limerick perhaps, I can take that quite swiftly because Mr. Cooper makes reference to those cases in his skeleton. He touched on them only briefly orally. I know the court will be familiar with those cases and time is limited, so I'll make, if I may, I'll simply make my point by reference to those. I accept that there is a line of case law. Well, I accept firstly this, that in Allenby, Lord Justice Sedley said that if the claimant requires a given criterion to be tested by reference to its impact, then it's not for the employer to put forward some other criterion that doesn't have an adverse impact. Secondly, I accept that where the PCP, the criterion is identified, the question, what is the pool for the purposes of the statistical comparison, is a matter of logic, although it doesn't mean that there will always be one result. You're essentially asking, well, to which group of employees is this criterion applied? And that's what those three cases are saying. But that's not in any way addressing the issue in our case. Ours is not a case where the impugned, we're trying to reformulate the impugned factor. We all agree that the factor is and a system which includes annual pay increases. Nor is this an argument about the pool to which that factor is being applied. We all agree that it's the two grades. The argument, or the relevant part of the argument, is about what constitutes particular disadvantage in the present context, which is not what either of those three cases has identified, is addressing. Mr. Cooper is saying, well, particular disadvantage can be assessed by reference to an aspect of basic pay, namely the amount by which it exceeds the minimum. and provided he can establish it particular disadvantage by reference to that aspect of the pay packet, he can win. And we're submitting, as you know, the particular disadvantage has to be in relation to the whole contractual term relating to pay. So the issue being addressed in those cases is simply not the issue before you in the present case. Can I then turn to the charge of our analysis being involved on the being based on the degree of disparity or the seriousness of an established disparity? And Mr. Cooper is saying, well, averaging is really, our answer to the case is really, well, maybe there was an average pay differential, but it wasn't sufficiently serious. And there I just wanted to remind the court, if I may, about the two broad types of indirect discrimination that have been identified in the case law. The first we've looked at, which is the question of what's described as a barrier criterion, which dictates access or otherwise to a particular benefit. And that's, you looked at it yesterday, Ches, paragraph 101. In that type of case, as I suggested yesterday, you know what the factor is, and the existence of advantage or disadvantage is already established, because either you're getting the allowance, in which case you're in the advantage group, or you're not, in which case you're in the disadvantage group. And the only issue is, but are women less likely to get that particular advantage? And so you look at the proportion of the women within the relevant group who get the advantage, and the proportion of the men, and proceed from there. But as I've talked to
it's at that point that Mr. Cooper says that you need to only look at the variable element. I appreciate you say you can't divide the term in that way, but let's just assume for a moment that we're against you in relation to that, and the reality is, or could approach it in that way. Do you say that way of considering the variable element wasn't the way this case was run and is not open to us now?
I do, as in my response to subground 3, say, number one, the case wasn't run in that way. So if you seek to prove a case by a particular method but don't run an alternative, you can't then complain that the tribunal rejected your primary and only case, which is what the tribunal said here, and advance some other basis on which the tribunal should have found in your favour. But I also say, I'll need to develop that in slightly more detail, but I'll also say that in any event, that argument based on averaging above the minimum produces perverse results, as ultimately Mr. Cooper recognises, because that approach means that the narrower the pay band, the more a given pay differential will seem significant. So if the differential is £100 and the pay band is from 0 to 1,000, then £100 is 10% of that pay range, and that looks rather big. But if the range is 10,000, then it's 1%. It looks rather small. And the perversity of the result is that Mr. Cooper's whole case is, well, you should have shorter pay bands. But his argument leads to the consequence that actually the longer the pay bands, the less likely he is to succeed. Can I turn then to Enderby?
This is your other broad type of.
That's the other broad type. Just as, and then we'll look at Balaba briefly, if we may. It's tab 7 for Enderby. I just wanted to go back to paragraphs 16 bear with me. It's not tab 7. That's
It is tab 7, it pretend to be.
that's odd. Oh, I think I know why that is. Yeah, it is. Sorry. So can we go back to page 161? So what I'm going to show you by reference to Villalba, or remind you of, is that the way that Enderby has been analysed in our case law is that you're looking at the statistics with a view to inferring that there must have been some form of discrimination historically. You can't necessarily identify the cause of the statistics, but the statistics are so stark that you can infer that there must either have been direct or indirect discrimination. We'll see that in a moment in Villalba. And so what you see the European Court saying at paragraph 16, as you saw yesterday, is that essentially identifying the parameters for potentially drawing such an inference, that if the pay of the speech therapist is significantly lower than that of the pharmacist, and they're almost exclusively women where the latter are predominantly men, there's a prima facie case of discrimination, at least where the two jobs are of equal value. It's for the National Court to assess. And if you look at paragraph 19, in these circumstances, the answer to the first question is that where significant statistics disclose an appreciable difference in pay between two jobs of equal value, one of which is carried out almost exclusively by women and the other predominantly by men, Article 19, what was then 119 of the treaty requires. And I emphasised appreciable deliberately. That is not to support a submission that you can argue, well, it may be appreciable, but it's not that serious. That's with a view to pointing out that what you're doing is looking at all of the evidence, including the level of the degree of pay differential, with a view to deciding whether you can infer that the pay differential must have been caused by something that discriminated against women. And so that's why our case does indeed say, well, you do need to look at what the actual pay differential is as part of the overall evidence, because that's part of the evidence going to the question, did the impugned feature of the pay system cause particular disadvantage to women? And then if we go to Villalba, that's tab 16. That's tab 16 of the authorities. If you go to paragraph 11, it's page 502. Paragraph 113. So in effect, this is Mr. Justice Elias as was, in effect, therefore, Enderby established that statistics alone may, in a sufficiently powerful case, create an irrebuttable presumption of prima facie indirect discrimination. Once there's a statistically...
It's a slightly odd way of putting it, but I see why he has to put it that way. Irrebuttable presumption, but of prima facie indirect discrimination.
He then, as you know, corrected to say, actually it's rebuttable, because you could prove that, in fact, you could attempt as an employer to
I'd
prove
forgotten
that
that. What, in a subsequent inserting
down.
Down,
Yeah.
right, okay.
But the crucial point is, what is it? Why are you looking at the statistics and the degree of pay disparity?
Yeah.
And once there is a statistically relevant and material evidence to demonstrate that the group is in fact being adversely affected on sex grounds, that will oblige the employer to justify the pay. It's not enough in those circumstances for the employer to demonstrate that the arrangements have resulted without any direct discrimination being practiced of any kind. In effect, the court is holding that there must somewhere have been some element of indirect discrimination. In other words, that there's assumed indirect discrimination. The statistics demonstrate a sufficiently marked adverse impact to constitute prima facie a case not requiring merely an explanation that the difference is not caused directly by sex, but in addition an objective justification. The stats must at least show that it's reasonable to infer that the treatment of the disadvantaged group must have related from some factor or combination of factors which impinge adversely on women because of their sex, even though no obvious feature causing because disparate treatment can be identified. Obviously, parts of that passage have been qualified, in particular the irrebuttable presumption, and of course impinge adversely on women because of their sex has got to be treated with caution in the light of Naim. But the central point is that the model, direct, indirect discrimination, is the same for all of these types of case. An Enderby case is one where you can infer that there must have been a factor which caused a particular disadvantage to women, and you can infer it from the various considerations that Enderby identified, including the fact that there's an appreciable difference in pay. Now, that is essentially what is happening in our case, that the question the tribunal was embarked on was the question whether a particular feature of the pay system indirectly discriminated against women, put them at a particular disadvantage, and as part of that question in our submission, it's perfectly legitimate to ask, well, is there actually a pay differential? And if so, how material is it, and so on? How significant? Well, those are my submissions on that allegation against us. Can I then turn to the question of novelty or established approach? Again, the Court of Appeal doesn't tend to decide the points on the basis of whether one side or the other's arguments are novel. But can I just make the point that Danfoss, of course, was a case based on average statistics.
Well, you'll have to remind us.
We could look at it in Enderby, actually, is probably what
Yes,
we're doing. Mr. Cooper showed you yesterday the reference to Danfoss at paragraph, I think, 15.
Well, it's not,
Paragraph 14 on page 161.
it's not actually called Danfoss there, but that's
That's right, it's called a much longer Danish name. So that's the case that says, well, if you've got a pay system that's lacking in transparency.
I see, yes, right.
But and Mr. Cooper appeared to be saying, well, that's a different category of case, but it isn't. The essential point in a Danfoss type of case is that the average pay of the women is less than the average pay of the men, and they're all doing equal work. So rather similarly to Enderby, you may then conclude, well, that must be the result of discrimination, and direct or indirect. And if the employer wants to show that it isn't, then the employer better show what the reason is. But it's the same starting point, that the differences in average pay are reflecting some form of discrimination or the result of some form of discrimination. So naturally enough, Mr. Cooper wanted to say, well, that is not really a similar sort of case. It is the same essential idea. And then he said that he knew no other case where averages have been used. Naim is a case where averages were used, specifically in the context of a complaint about the impact of length of service. The comparison being made in Naim was a comparison of the average pay of the Muslim chaplains with the average pay of the non-Muslim chaplains. It's tab 23, paragraph 14 on page 1350.
Which page, sorry?
Page
Paragraph
13. 14. So Naim, as you know, is a similar type of case where you had pay scales with annual pay increases. The position was, as you'll recall, that Muslim chaplains had not been employed in the prison service until much more recently than Christian chaplains had been. Yep. The consequence of that was that they'd had fewer opportunities to increase their pay on these scales. Yep. And the issue was whether that was indirect discrimination. But the particular disadvantage was put specifically in terms of difference in average pay, as you can see.
Though in fact, almost certainly, you could have done a similar clustering analysis. You've done it in a graph, or indeed in quartiles and deciles, you would have seen disproportionate numbers of Muslims Muslim chaplains at the lower end of the scale.
I agree. But that, it just brings us back to the essential point that if in Naim the approach had been just to say, well, let's plot the pay rates of the Muslim chaplains on a graph, or put them into a table by reference to ranges or otherwise.
Yeah.
We would have said, well, yes, you're looking at something that tells you there may be a problem, but what you need to do is go on and say, but is there a problem? And ask it.
In that case, you would have found one. In that case, you would have found one.
That's right. So, in my submission on the battle for novelty or orthodoxy.
Does anyone actually be going to say, may not matter, what's the percentage difference between 31847 and 33811?
I don't know, but it must be in the order of 10%.
No, less than that. Oh, perhaps you're right. No, sorry. Yeah, less than that, but perhaps not much less.
So
it doesn't matter.
If the question of obviously not, if the question of orthodoxy versus novelty is a winning argument, I do submit that I've demonstrated this morning that our approach is entirely in accordance with orthodoxy. And if this court were to say, well, the distribution analysis is the only basis on which you can approach this type of case, then it would, in my submission, be saying that the EHRC code was wrong, so is the toolkit, and that actually these cases, although particularly 9 proceeded on looking at the wrong thing, it didn't matter that it was looking at the wrong thing. That then brings me to the question, what did the Employment Tribunal do in the present case? If I can just put away the... Now, you've read obviously that Mr. Cooper's case evolved, and there's absolutely no criticism of him for that, especially in an employment type of a case. And I just want to show you, so that we're specific about it. He did make reference to averages in his pleaded case. So if you've got page 141. You'll recall that there were various repleadings of the case. Again, no criticism of the claimants. That was for various case management reasons. At this stage, 1st of October 2014, at page 136, the claimants gave particulars of their case on particular disadvantage. They appended, as you can see, Dr. Hall's report as the basis for their
I'm sorry, I think I'm looking at... Which bundle should I be looking at?
Page 136, tab 7 of the core bundle.
Oh, right, yes, sorry. So we're in the Tribunal's reasons.
No, it's a supplementary bundle.
It's a supplementary bundle, I'm so sorry, my fault.
That's what it must be. Yeah.
So they produced particulars of their case on particular disadvantage. They enclosed the report of Alison Hall advocating the distribution-based approach. And then if you have paragraph 11, they then condemned the crude averages approach. And they then said, in the 5 lines at the end, at most, a comparison of averages, whether mean or median, may be used as a secondary method for double-checking the impact, since the alleged effective length of service in this case would tend to produce consistently lower average pay for women than men within the relevant grades, though the differences in percentage terms may indeed, for the reasons set out above, be relatively small. And there's further reference to that point if you've got it at page 1.43, paragraph 15. So they say they're not pursuing the pleaded case based on averaging, but they then say, however, for reasons set out above, comparison of crude averages doesn't constitute meaningful, logical, or appropriate methodology for assessing particular disadvantage in this case. Nevertheless, as a secondary check of the kind at paragraph 11 above, they then say, they then make observations about the mean and median salary. My lords, while we're in this document, looking ahead to subground 3, there's, if you look at page 140, you can see footnote 3, which is I'm going to refer to in a moment about the in relation to the extent of Mr. Cooper's development of any alternative case based on average pay above the minimum. I don't talk you with that at this particular point. Written submissions were then put in, as you'd expect, and characteristically erudite ones by Mr. Cooper, and they appear at page 65 of the supplemental bundle. And it appears that at this stage Mr. Cooper has become more convinced of the intellectual purity of his approach, because the written submissions are entirely a very well-reasoned case as to why the distribution approach is the only right approach. So when one then looks at the Employment Tribunal decision, for which we need to look at the core bundle, obviously.
They're not inviting you to. You're not taking to any particular passage.
No, all I say is, at that stage, he advances a very detailed case, but the only case he's advancing is the distribution analysis, or bust.
Yeah.
And it's the same as this case here, and one has to commend his courage and his intellectual integrity in persisting in the argument. It's just that we say, unfortunately, it's wrong and correctly rejected by the tribunal. If we go then to page 135 of the core bundle,
One which...
is page 135 of the core bundle.
135, yeah.
The tribunal set out, as you've seen at paragraph 4, the argument that was being put, but notably for my purposes, subparagraph 3, that he was not submitting that he could or should win on the basis of the average pay statistics. He accepted that they did not show significant long-term differences between the pay of the men and the women. And then at page 151, paragraph 41.3, so that's subparagraph 3 towards the top of the page. These are a summary of Mr. Cooper's submissions.
Is mean average a tautology?
Well, the median might be regarded as a measure of average, but...
Oh, I see.
So comparison mean averages, as proposed by them, doesn't assist in a proper evaluation of the claimant's case, because it brings into account the large part of basic pay which is unaffected by the factor, and it masks differential distribution by smoothing it out. And then actually his case is a distribution-based case incorporating Dr. Hall's chi-squared analysis. And you've seen that Dr. Brown, for reasons which the tribunal's explained in its judgment, and you've seen in his report, said that the distribution-based approach and the application of the chi-squared test was meaningless. That's paragraph 29 of the Employment Tribunal's reasons. And at paragraph 45, you've seen the tribunal accepted Dr. Brown's evidence in its entirety. So at paragraph 50 then, it comes as no surprise to read that therefore the claimant's case was rejected. They had advanced a distribution-based case only. Dr. Brown, for the reasons which you've seen, had said that it was meaningless. The right way to look at it was to look at the actual pay differential. And so the tribunal records that the claimant's case is rejected. The result is that they fail to establish particular disadvantage by their chosen route of distribution-based analysis. No alternative is advanced. And as I've noted, they do not dispute that the average figures do not disclose significant long-term differences between basic pay of men and women in either of the two relevant grades. I'm in no doubt that they're right to accept those figures are against them. The respondents have demonstrated, not that they bore any legal onus, that the differences in basic pay have been consistently marginal and diminished over time and will diminish further as time passes. So I'm entitled to say that even if Mr. Cooper had advanced a case based on average pay, the tribunal found on the facts that that case would not have been made out because the differences were consistently marginal and diminished over time and would diminish further as time passes. But the important point for the purpose of the present appeal is that even if the tribunal hadn't done that, that's essentially my fallback position, what the tribunal had done was identify Mr. Cooper's chosen route, assess it, conclude that it was wrong, and dismiss his case in circumstances where the burden of proof was on his clients. And since no alternative was advanced, that's ultimately in our submission the end of the matter. Can I turn then to subground 2, which is Mr. Cooper's submission that there was only one answer in this case? Well, I've addressed that already in seeking to persuade you that the distribution analysis was rightly found by the tribunal, permissibly found by the tribunal, not to lead to the conclusion for which Mr. Cooper contends. So there's an issue there about the right approach. But Mr. Cooper also advances a case that, well, actually, as it turned out, Dr. Brown agreed with him that the distribution result was in fact significant and meaningful, and that therefore it was perverse of the tribunal to find otherwise. And he says, well, that's by reference to the notes of the cross-examination. He showed you Mr. Brown, Dr. Brown saying, well, you could apply the chi-square test. But as the Employment Appeal Tribunal found, if there was to be a perversity challenge on the basis that actually, having said all the things that he'd said in his reports, there were various different iterations of his position, but they came to the same thing, he'd suddenly changed his mind in the course of cross-examination and accepted that actually this was meaningful and the chi-squared test could be applied to achieve a statistically significant result. Then in my submission you would have needed the employment judge's notes to make good that proposition. I accept, as you've seen, that he did say, well, it could be applied, just as it could be. It could mechanically be applied. But his clear position was that it wasn't appropriate to apply it because it was only appropriate in cases where there was categorical data.
That's your real point, isn't it? I mean, we've got the notes taken by the solicitors, and they essentially agree on this point. There's no dispute as to what they say. You need to get the employment judge's notes.
Well,
There's discouraged from asking the employment judge's notes unless the parties can't agree on a note.
You'd have to come to the conclusion that the judge hadn't, that the way that Dr. Brown expressed himself in cross-examination.
That's a different point.
The judge.
Yeah, no, I fully understand that. Don't get me wrong. All I'm saying is, if you're taking a technical point about this point isn't open without taking the notes, I'm not sure that's your best point.
Not a technical point. No, not that, oh, there's a rule, you've got to have the employment judge's notes to win on a perversity appeal. But it would certainly have assisted to have a clear idea of how the judge was seeing it in terms of the notes that he took. If it's being suggested that a statement you could apply it is actually acceptance that you would then get a meaningful result. So it depends on how you emphasise it. Well, you could apply it. And I did re-examine on that question, and I just wanted to show you Dr. Brown's position did remain as stated in his report. That's supplemental table, page 312. If you've got above item 87 re-examination question, in order to reach a conclusion you need to test statistical significance, answer in order for me to draw a conclusion. I wouldn't do it on visualisation. And then the respondent's version, you say in order to reach a conclusion you need to test the data for significance, yes. Then the claimant says we apply the chi-square test. You say it is a measure. Do you get a reliable or unreliable result? And D-cells, quartiles and so on, Dr. Hall identified and he says it's a reliable result based on the transformational data. The distribution of men and women across the four quartiles in the pay range are different. Do you accept that it's okay to transform the data? No, because you've got richer data distribution you can test. You don't have to categorise to test the data. And in the right-hand column, similar entries. Against GB item 88 on page 313, reliable based on transformed data, tells us the distributions are different.
Yes.
I don't accept the transformation of the data is valid. You're not using all the data available. So, brilliant as Mr. Cooper's cross-examination was, it wasn't one of those unusual cases where Dr. Brown suddenly said, oh no, you're right. If I can turn then to the question of the alternative case that's advanced by this is subground number 3. As you've seen, the tribunal said at paragraph 50 no alternative was advanced. So again, Mr. Cooper's argument has to be, well, that's simply a perverse statement of what happened at the tribunal. In a way, that's the long and the short of the point, but you've got the history set out in the Employment Appeal Tribunal's judgment. You'll have an opportunity to look again at the pleaded case, and I pointed out footnote 3, but that was attacking our approach as to saying there's an alternative approach that I wish you to consider. And actually, it was doing it on the basis of a different statistical methodology to Mr. Cooper's current one. You've then got the point that there were exchanges of expert reports. Dr. Hall, for example, did look at mean and median data, but didn't seek to subdivide it into above the maximum or below. Dr. Brown wasn't asked to comment on that issue.
I'm not trying to shut you off, but just for my own note, these are all essentially the points made by Mrs. Justice Simler. You're not making any different points. So.
Yes. In the ET submission, in the written submissions that you've got in the supplemental bundle, no alternative case advanced, we're agreed that Mr. Cooper did in cross-examination put to Dr. Brown that, on the basis of a slightly different methodology, that the averaging approach, if the whole pay was taken into account, would have a distorting effect. And we agreed that the same point was made in closing submissions, but then it was specifically stated no alternative it was specifically stated that they weren't advocating such an approach.
Yeah.
So we do say that it isn't open to Mr. Cooper to ask you to set aside the tribunal's judgment on the basis of subground 3, i.e. that there's an alternative route to success for his clients. That simply wasn't a route that was advocated before the Employment Tribunal. Lastly, under this heading, question, well, if the route is open to him, is it a sound route? And I've developed the arguments by reference to the statute or otherwise, that what you're concerned with is the actual term as to basic pay, and the notional subdivisions in our submission are not permissible in this context. But can I also point out that you get perverse results in a number of ways? I pointed out that one of them, which is that actually, if you take this approach, the shorter the pay scale, the more significantly, or the greater the likelihood of establishing particular disadvantage. But you will have noticed if you take up paragraph 65.1 of Mr. Cooper's skeleton and Ms. Criddle's skeleton argument.
Sorry, which paragraphs?
65.1 on page, well, it's internal page 20 of the skeleton argument, 24 of the bundle. You'll have noticed that consistently with the point that I've made about the shortening of the pay scales giving the appearance of more significant pay differentials, that although you've gathered from you have gathered it from this data, but also from page 315 of the supplemental bundle, that the pay scales are in fact narrowing. So the problem was being solved, not as fast as Mr. Cooper or others would wish, but the problem was being reduced, if I can put it in those terms. On Mr. Cooper's approach, the right-hand column actually shows it the situation not improving. So you can see that in each of the cases, precisely because the shortening of the pay scale results in the same differential becoming more significant, steps being taken to improve the position were in fact resulting in, according to Mr. Cooper's analysis, in his case getting stronger. And that's why the percentages show, for example, in relation to G6 London, that although the scale has narrowed, in fact the male to female differential is now 29%. Similarly, when you look at these figures, you'll see that actually the actual average differences in pay were also reducing between men and women on average. And yet Mr. Cooper's approach is showing that the situation is getting worse in terms of the differential. And similarly, Mr. Cooper's approach means that the nearer to the minimum the men's pay is, the greater the pay differential. If I can just seek to at least try to explain that point. What he's done is use as the denominator the extent to which male pay is above the minimum of the grade. So if we take up page 24 of the G7 national statistics.
Sorry, where are we going?
We're looking at paragraph 65.1 still in the skeleton.
You said take up page 24.
Sorry. Paragraph 61, the data on that page.
Yeah.
So what you can see, what he's done is he's looked at the average variable pay for women above the minimum in each year. He's looked at the average variable pay for men in each year. He's then identified the male to female differential, which you can see is narrowing, although the statistics suggest the position is staying the same, the percentages suggest it's staying the same. And he then divided 1216 in the top column by 4528. So the denominator is the average pay of the men. And that means obviously that the closer the men's pay gets to the minimum, so in other words, if the average men's pay is going down to be closer to the minimum, the lower the denominator will be, and therefore the higher percentage you will ultimately get. So, my submission, we're now obviously in the realms of what most tribunals regard as quite complex statistical cases being put on both sides, with no right or wrong answer. One could see why Mr. Cooper has taken his approach, but other approaches could have been taken to assessing the significance of the difference in average pay above the minimum. And our submission, that's another indication that taking notional subdivisions of contractual terms for the purposes of analysis is not what the legislation intended. As best it could, it obviously hasn't necessarily succeeded in this aim. The aim was to ensure that the legislation was capable of application by the sorts of people who have to apply it. And our submission is that his analysis ultimately has the contrary effect, and for that reason, whether or not it produces unfair results on either side, both sides argue it does, it's the wrong approach. Well,
How are we doing?
We timely question, because I was about to say that those are my submissions. Is there anything else you wish to ask me?
Right. Nothing I wish to ask. No, my lords. Yes, Mr. Cooper.
My lords, I think I count 10 points that I'm going to make in reply. I'm going to rattle through them as fast as I can, and I always seem to find that I miscount when I stand up to reply, so apologies if it ends up being a different number from 10. Can I start just by revisiting the point of principle, which it's always useful to do in light of the clarification that and refinement that happens through argument. My Lord Justice Ryder is right to say that through the course of argument I somewhat refined the way I put the principle. It doesn't undermine the essential thrust of the case, but can I make clear how I put the principle now? The central principle is you are always looking at whether women are more likely to be paid less. And the consequences of that central principle, which are key to this appeal, are firstly that any test or evidence that is adopted or analysed must A, be relevant to that question, and B, must always be analysed by the tribunal for what it tells you about that question. Secondly, average pay may therefore be relevant depending on the particular facts of the case, if it is either a reliable proxy for measuring whether women are more likely to be paid less, for distribution in effect. And for that purpose, you will usually be better using average variable pay, not average total pay. Or it may be relevant, if you're looking at average total pay, as a cross-check. Provided, as I say, in conducting any of those analyses, you take account of the effect of bringing in all the bit that isn't variable. So, Mr. Linden says we're in the realms of presenting to the tribunal complicated statistical cases. And unfortunately, that has often been the case in indirect discrimination claims where statistics are relied on. The authorities are replete with difficult questions about how you analyse the statistics. But that's not an answer to the point of principle about what it is that you have to measure, and frankly the need for the tribunal to ensure that it understands and analyses what is going on behind the figures. So Mr. Linden says you need to do that in relation to our alternative case. I may come on to that shortly. But equally, you need to do that in relation to any reliance that's placed on averages on the claimant's case. So that's point one. Point two is that a consequence of that point of principle is that it is an error of law for the tribunal to say, as it did, and as the EAT also said, that a distribution analysis must be excluded is not a permissible analysis because it's substituting an abstract for actual pay. It's also an error of law for the tribunal to say you must show, the only way you can prove your case is by showing a substantial difference in average total pay. That's what the tribunal and the EAT did, and it's what Mr. Linden submitted to you this morning. He said to you in terms, unless you can show a difference in total average pay differential, his term, you can't succeed. That's wrong in principle because it's looking at only one potential part of the picture. It's excluding the other potential parts of the picture. And most importantly, going back to my point of principle, what it's doing is not analysing the figures that are being relied on for the correct purpose. Because what it's saying is you have to look at them for a pay differential, not for what they tell you about whether women are more likely to be paid less than men. Thirdly, can I briefly address how the case was put, which will wrap in a number of points of reply, because Mr. Linden sought to rely on differences in the way he says the case were put at a number of different points in his argument. We were saying, and we still are saying, that on the facts of this case, distribution is the right approach and is sufficient for us to win. And we were saying, and are saying, that total average pay is not the right approach because, for all reasons I developed, it measures the wrong thing. But we did also say, before the tribunal, before the AT, in terms in our pleadings and in oral submissions, I accept the point wasn't developed in my opening skeleton argument for the tribunal, we did also say that although our primary position was distribution was sufficient, the averages that were apparent in this case, are apparent in this case, actually support the primary case that we were advancing based on distribution. Mr. Linden took you to some of the relevant materials in the supplementary bundle, but can I just go briefly back through them to make sure that I emphasise the key points. First of all, at page 140, in the further particulars of our case on particular disadvantage.
What page did you say?
140 of the supplementary bundle. In the course of setting out why the claimant's approach relying on total average pay was wrong at 10.4, we emphasised the point that has been running as a thread through this case all the way.
Sorry, could you ask the gentleman wandering around the court to sit down?
Yeah, thank you.
We were emphasising the point that runs through the case as a thread all the way, that the claimant's approach is distorting because it brings into account the non-variable bit. And we made the point expressly in the footnote that therefore if you were going to rely on averages at all, you had to do so, you would have to do so by analysing them within the variable portion only. And over the...
Let's just not sure I've read this footnote right through. quite dense stuff. The fourth line, you say, therefore, if, contrary to the submissions set out herein, and then you go on to make the point you've just summarised, but that's not really making part of your case, even on an alternative basis. Or have I misunderstood how you're putting it?
Well, no, I'm not suggesting that I advanced a fully developed alternative case. What I am saying is we relied on the differences in average variable pay principally as a basis for attacking the approach of the claimants relying on total average pay. And my main point in relation to that, which I'll
So,
cover...
hang on 1 second. So that's in the text at 10.4, not in the footnote.
That's in the text at 10.4,
Yes.
but it's then making the point in the footnote that if you substitute, or if you look solely at variable pay and the averages within variable pay, that to some extent removes the problem with averages. It doesn't remove all of the problems because you're still smoothing out differences and you're still taking into account people who are advantaged as well as those who are disadvantaged in looking at that that figure. So I do accept this isn't advancing an alternative case in the footnote. What it's doing is relying on the point in order to attack the case as advanced by the claimants. And the main point I rely on all of this for is that it was the incumbent on the judge to address that if he was going to. But I'll develop that in a moment if I may. Then over the page, what we did say at paragraph 11 was the last 5 or 6 lines of that paragraph, that at most a comparison of averages may be used as a secondary method for double checking the impact, since the alleged effective length of service would tend to produce consistently lower average pay for women and men within the relevant grades, though the differences in percentage terms may indeed, for the reasons we've been developing, be small, relatively small. And that was emphasised further, as Mr. Linden took you to at paragraph 15 on page 143. Picking it up at the end of the 4th line. The claimants do not therefore allege that the differences in average pay have been consistently greater than 3% and do not pursue the allegation in paragraph 7c of the details of complaint to that effect. So that was the extent to which we were withdrawing the originally pleaded case, where, based on information from the respondents' equal pay audits, it appeared at the time of pleading, before we had all the raw data, that the differences were in fact greater than 3% and would have met, on any view, the EHRC's guidance. So, the answer to Mr. Linden's point as to our case having changed is, well, if that had been right and what appeared from the equal pay audits had been correct, we wouldn't have been having any of these arguments, because the respondent would have had to concede the point even on its own approach. But Mr. Linden's right. When that doesn't appear to be the case, we're driven to think about it again and consider what the evidence does show. And on doing that, we make this point, and it's a point that I'll come back to shortly in relation to an important concession made by Mr. Linden. But what we were plainly saying was that as a secondary check, it may again be something that could be used to check whether the apparent distribution is in fact a reliable distribution. And then in our written opening skeleton argument before the tribunal, which begins at page 10 of the supplemental bundle, but can I go please to page 55 of the bundle, sorry, page 90, sorry, it doesn't begin at page 10, it begins at page 65, can I go to page 92 and paragraph 55, it's up there. structure of the analysis in these submissions was to identify the various approaches that had been adopted in previous cases. And at paragraph 55, I made the point that this wasn't a requirement or condition case, nor a lacking transparency case, because you can go back and reconstruct why each element of pay of each individual has got to where it is. But it is a case where the factor length of service operates to determine an individual's position within a given range, along with other factors, and I'll come back to that. So it's much closer to the traditional requirement condition case. And what you can't do, this is the point I made to the judge, point I reiterate before your lordships, what you can't do is say, well, because it's more difficult, we'll abandon the principled approach that applies in a requirement condition case and do something different. We'll look at pay differential instead of differential incidence of lower pay. And we made the point again over the page at paragraphs 58 to 60 that therefore you need to focus on the variable part of pay. That's always been central to our case. And then we made the point at paragraph 62 onwards that you need a test for distribution. And the argument follows much of the argument that's been presented to your lordships. Moving on to page 96, the concluding point in these written opening submissions was therefore that what you require is not a measure of the amount of pay at stake.
Sorry, where I'm on
Paragraph 73. Therefore, what is required is not a measure of the amount of pay at stake, let alone average percentage difference, but a measure of the differential distribution. And then I said there are various ways in which that might reasonably be tested. And then at 74.1, in terms, most straightforwardly, you look at the distribution quartile decile analysis, and that by itself may demonstrate a clear and significant disparate impact. Then you could do the Barry cross check, and then as a third check, you could do the chi-squared test. And then finally in closing oral submissions, there wasn't a separate written closing submission produced. This was heard over the course of, I think, 2 days from recollection. In closing oral submissions, I again drew the judge's attention to the variable pay point, and I accept Mr. Linden's account of that. It's recorded by Mrs. Justice Simler in the EAT's reasons, but I very clearly said to the judge again, if you are going to look at averages, you would have to do it by looking within variable pay. And I'm not advancing averages, I said, but that's the point you make. So essentially, again, I was making it as a point of attack in relation to the reliance on total average pay, and it was incumbent on the judge to deal with that point, which, as I say, I'll come to. So that was how the case was put, and all of those points were very clearly before the judge. The same points were canvassed before Mrs. Justice Simler in the EAT. And I come then to two important concessions made by Mr. Linden.
Are we still on your third point?
I've just finished my third point.
Right.
The first of Mr. Linden's concession.
Is your first point?
Concessions is my fourth point.
Yes, sorry.
And what I'm going to do is explore the implications of these concessions in turn. His first concession yesterday was that he accepts that because of what Ches says, a persistent average pay difference of even 1 or 2% would be sufficient to demonstrate, even on his approach, particular disadvantage if, and the caveat he gave to that was if it was clear that it's caused by length of service. It's a little bit tit for tat, but it is important for me, before I explore some of the implications of that argument, to note that that is not how the respondent's case was put below, or indeed in the Employment Appeal Tribunal. Still in the supplemental bundle at page 107. These were the respondents' written submissions before the ET. Paragraph 9.2. Contrary to the claimant's arguments, the statistics in this case show only a marginal pay differential between men and women, which is well below the differential which the Commission's guidance suggests may constitute long-term and persistent pay differences that are statistically significant. It's in any event diminishing and does not constitute a proper basis for establishing that women are put to a particular disadvantage. So, really, that submission before the tribunal, which was accepted by the tribunal, is diametrically opposed to the concession Mr. Linden makes to you today, because in relation to 9.2.3, he's now accepting a small pay differential may be sufficient to show particular disadvantage, and contrary to 9.2.1, he's now accepting that it doesn't have to be above the 3 or 5% thresholds in the Commission's guidance. So on the approach that he now submits is the correct approach, what the tribunal ought to have been looking at was not, is this above or below 3 or 5%, but what does this show us about whether there's a persistent pay gap of any size? One of the points Mr. Linden takes against me is to say, well, how is the tribunal to know when a differential distribution meets the threshold?
Harold, this isn't the case that's being put. Well, subject, we'll have to think about your third point.
Yeah.
But this is only relevant if you persuade us that you were putting an alternative case on averages, isn't it?
Well, no, this is relevant because Mr. Linden's concession is in effect a concession that the case that he put to the tribunal and the tribunal accepted was wrong in law. Because he now concedes that it is sufficient for a difference of even 1 to 2% to be evidence of particular disadvantage.
Well, I don't see how that's an answer to the point I just put to you. If a case was being put on averages,
Yes.
and had been defeated because he persuaded the judge that anything under 3% didn't count, then you'd have a point. But it wasn't, so you don't. Unless you're showing me you did.
Well, I am saying a case was put on averages to the extent that I said to the judge, first of all, in the pleadings that I've taken you to, that the small averages in this case are explained by taking into account the bit below the minimum, but nevertheless support, as a secondary cross-check, the differential distribution analysis. And secondly, if you take out the bit under the minimum, that becomes even more apparent. So it was incumbent on the judge to analyse those points and consider them, instead of simply accepting the case as put on behalf of the respondents, that you have to look at total average pay, and you can only succeed on total average pay if it goes above 3 to 5%.
He didn't have to accept, he had to reject your case.
Well,
He didn't have to accept an alternative case.
No, but the basis on which he proceeded at paragraphs 43 and 44 of the judgment was not to say, I'm looking at various different measures and I conclude that the distribution method is not telling me anything in this case, and I conclude that the averages are not sufficient to establish particular disadvantage. The way in which he put it was, you can't look at distribution, paragraph 43. You have to do it based on averages. These aren't sufficient. He doesn't refer to the 3 to 5%, but it's clear he was accepting the claimant's case because Mr. Brown's evidence was 3 to 5% is the statistically significant threshold.
If you're right about that, it needs to be, it would have to be remitted.
Well, it would have to be remitted if you conclude, unless you conclude that I'm right on my primary case, that if you look at the...
But you only need this bit.
Yeah, I only need this bit if you're against me on my primary case, that if you look at the statistics of clustering alone, that's enough and gets me home.
Okay, well, I think we have your point on this.
My Lord, I'm grateful. Can I deal, I hope, as briefly as I can with what, I confess that is a submission I struggle to follow a little bit, but Mr. Linden's, this is before I come to the second concession because it fits in here, Mr. Linden's more general point as to whether or not, or that, as he put it, there was a question as to whether length of service was the cause of any difference or differential distribution in this case. And he seems to be saying that that somehow affects the test that you apply for looking at particular disadvantage. But with respect, they're two separate questions, and it's never been in dispute that there are three factors which can affect where you are between the minimum and the maximum. Length of service, pay progression, length of service, performance, and where you start within the range. There's no conceptual difference when you're doing the analysis of whether women are at a particular disadvantage by the fact that you have more than one factor that can cause the overall position in terms of pay. So what you're still looking at is whether women are more likely to experience lower pay, and if so, whether length of service is the cause of that. So that's the sequence of the analysis that you can do. And in order to do that, you start by looking at the differential distribution. That's whether they're at a particular disadvantage. And then you ask the question, is that because of length of service? And in this case, you can establish that it was length of service in two ways. That the principal answer to Mr. Linden's point, and is the one that the judge went with. The judge accepted that the differential distribution was because of the more recent recruitment of women. See paragraphs. Paragraph 65 of his judgment, page 158 to 59. But secondly, I took you yesterday to page 168, 14 within the core bundle, which shows if you eliminate length of service, the effective length of service, there's no pay differential, even on Mr. Linden's approach, so it eliminates any effect. So the argument, for whatever it was worth, that somehow the question of whether length of service is the causal criterion affects the approach that you must adopt in relation to assessing particular disadvantage doesn't take Mr. Linden anywhere, either as a point of principle or on the facts of this case, because actually there's never been really any dispute that length of service was the relevant factor in this case. And it may be worth for your Lordship's notes just noting at paragraphs 30 to 33 of the judgment, there was a debate before the tribunal about how the factor should be defined and analysed. It's much the exchange your Lordships had with Mr. Linden this morning, that in the end the position reached was the right way to analyse it was its length of service, because that's how you primarily move through the scales. That brings me to my fifth point and Mr.
It also
Linden's...
brings you to...
It brings me to 1 o'clock.
1 o'clock. Now, unless my lords kick me up the table, as we've found a way to do, I think we will be certainly prepared to sit on for a short time to finish. On the other hand, unless your remaining points are much shorter than your first, which they may be, it's better to bite the bullet now and say we'll come back at 2 o'clock. Give us a realistic estimate.
20 minutes.
Yes.
If it's not a punishment to the court staff, I think it's probably, better for everyone while we're in the flow. Okay? I'll try not to ask you too many different questions.
No, well, please.
You, I'm sure, will try to be concise.
I will. My fifth point and Mr. Linden's second concession, he accepted that the effect of including the minimum below the variable amount of pay is, on his analysis, part of the explanation for the apparently small percentage differences in total pay. But he said the other factors, which I understood him to mean performance and starting salary and grade, were part of it too.
Well, I think he mentioned other factors, such as the possibility that women were moved out of the grade disproportionately.
Sorry, I don't follow.
If women are promoted, or
Yeah.
for any other reason, out of the grade disproportionately, that will mean that they are more likely to cluster at the lower end.
Yes, that's what I encompass within starting salary within grade. So the three factors that...
Yeah, that's a good point. If they come out of the grade, they're only in...
Oh, I see, yes. That could be a factor.
Yeah. Anyway, carry on. What do you say his concession was?
His concession was that part of the explanation was that you're bringing into account the bit below the minimum for the apparently small percentages in total pay difference. And that must be right mathematically. We explored that yesterday. But that concession, just looking at the implications of that, supports our submission to the judge, which he should have and failed to consider, that was the principal reason in our submission. It's really the only reason for the apparently small differences in total average pay. And at paragraph 44, we went to it yesterday, the judge instead says the explanation must be because of reverse clustering within quartiles and deciles. And notably, Mr. Linden didn't seek to support that conclusion. So the effect of Mr. Linden's concession on that front is that the judge did, in failing at that paragraph,
What's the para number again?
44,
Yeah.
to analyse the case that we were putting to him as to why the percentage differences were small, and reached a conclusion which he said inevitably followed, but even on Mr. Linden's concession, obviously doesn't inevitably follow. And what that underpins, going right back to my core point at the start, is that what the judge was not doing was analysing average pay for the right reasons. He wasn't considering what it showed about whether women are more likely to experience lower pay of any size. He was solely focusing on the size and difference of average pay. My sixth point is to address the hypothetical statistics that were put to you this small. Can I go to the last of those, because they are the ones that perhaps closest to any sort of real scenario, although obviously not. The last of those, the fourth of those, essentially seeks to create a hypothetical case that reflects the judge's incorrect conclusion as to what was going on here. And the short answer to all of this is that there was no evidence before the judge that was the case here. Secondly, it's a highly improbable...
No evidence of what I think you called earlier, the first time we've heard it, reverse clustering.
Yes, it's reverse clustering
Yeah.
within the clusters. And it doesn't make Mr. Linden's point that on our approach, it is theoretically possible that an employer could be required to justify on a distribution analysis pay scales where average pay is in fact higher for women. The reason it doesn't is because it ignores the cross-checks that have always been inherent in our approach. If you divide this hypothetical situation into deciles, then the people at the top and the bottom of each of the relevant quartiles will be in different deciles, and you will immediately expose the reverse clustering within the quartiles. So on our approach, this wouldn't be one where we would be saying it has to be objectively justified. And the same applies to examples 1 and 2, because in neither of those is there in fact a differential distribution. And example 3, the percentage figures given in bold at the bottom are not adopting the Seymour-Smith type approach. They're adopting an approach which Mr. Linden says is derived from the regulations. Won't take you to the regulations, but it's relevant to look at Regulation 13 together with the definition of a relevant full-time employee in Regulation 1.2, because they're just doing something completely different. What they're asking employers to do is rank everyone in their employment, regardless of grade, from top to bottom, and then say divide them into quartiles by reference to the numbers of employees, not the range of pay, and then say which proportions of men and women are in each of them. So it's just not a comparable exercise. It doesn't take us any further in this case. Seymour-Smith tells you what is the right approach for comparing proportions in a case where you're looking at differential impact. And in that regard, you end up in this instance with very small numbers, so relatively large proportionate differences in the top and bottom, but equal numbers in the middle. And the answer is you probably have an argument even on a distribution approach as to whether that showed anything in this case, and Mr. Linden could wheel out the averages as a cross-check to say it doesn't get you home. So on the approach I'm advocating as an approach of principle now, again, this case would not succeed. So for what they're worth, those hypothetical examples don't take the matter any further, and in any event they're highly improbable. My seventh point is to address the Brown logic, if I can put it in that way, at pages 188, 189 of the supplementary bundle. We needn't turn it back up again. But there's a fatal flaw in the Brown logic, and it's this. He says the problem with quartile analysis, by which you take the bottom of the pay scale, the top of the pay scale, you divide it into quarters, and you look at the proportions in each. So you look at only variable pay. It's the starting point for his logical reduction. He says the problem with that is you're lumping together people who are actually at different pay points into quartiles, and so you need to do the decile analysis to cross-check that, but then that might be wrong in itself, so you need to divide into smaller portions, and in the end you end up with actual pay points, and the only way you can properly analyse those is averages. But the fundamental flaw in his logical analysis is that he jumps from all the way through subdividing a focus on where you are within the variable range, which is the correct question of principle, because you're looking at whether women are more likely to be paid less than men. But at the last stage of the analysis, he then says, so you're left with having to look at averages and therefore total average pay. And it's that jump from variable to total that is the non sequitur in his analysis. So actually, the logic of Mr. Brown's analysis is that you end up, if you're looking at averages at all, and as we've always put it, at every level, if you're looking at averages at all, you're looking at averages of variable pay. My 8th point is in relation to justification. Mr. Linden relies on his argument in relation to justification in order to say that you have to test particular disadvantage by reference to pay differentials, total average pay. So if he's right, it's a point I made yesterday, but I need to reiterate it in order to explore his submission. If he's right, then he must be saying that in all the old cases where you used to do a differential analysis based on proportions in different categories, all those are wrong as to how you test particular disadvantage, because when you come to the justification stage, what you have to justify is the value of actual pay differentials, as he puts it. So if he's right, then you can't, at the justification stage, have to justify in an old binary division case the fact that women are disproportionately in the top bit and bottom bit and men disproportionately in the advantage category. You can only look at actual pay differentials. The other problem in his analysis is that this is one of those instances where he confuses actual pay with average pay. Because if what you have to justify is an average pay difference, then that's no more an actual pay difference than a distribution difference. Both are abstractions from the statistics. The answer to his point is that there is simply no problem on the statutory language or on the structure of the statute in saying that at the particular disadvantage stage, what you have to look at is evidence of differential impact, because that's what you're required to by CHES and by all the authorities. And because the statute under section 69.2 is focusing on the causal effect of the factor. But when you come to section 69.1a, different subsection, the question is a different one. It's whether or not the factor within the pay system is justified. And when you look at that question, there's nothing in the statutory language that says you can only look at the particular disadvantage that's been looked at in relation to subsection 2. It says in terms what you have to look at is whether the factor is justified, and nothing in principle as to bringing into account at that point actual differences in pay. And I emphasise that because I mean it literally in terms of actual differences in pay, not average differences. When you get to the justification stage, you're going to be looking at claimant A and comparator B, the difference between their actual pay, and saying, based on the factor of length of service, is that pay differential justified? That's the question under justification, and nothing in the statutory language makes anything difficult about that and about applying those tests in that way in relation to the two different provisions. Can I just take 2 points in order to illustrate that? First of all, consider just a conventional requirement or condition case. In order to be paid £5,000 extra, you have to be over 6 foot tall. At the justification stage, at the particular disadvantage stage, you look at the figures. What's the proportion of women who are over 6 foot and under 6 foot? What's the proportion of men over 6 foot and under 6 foot? And then at the justification stage, you bring into account both the discriminatory effect revealed by that particular disadvantage, probably significant, and then what's the reason for it? And is £5,000 a proportionate amount to a proportionate value to place on that difference? So in those conventional cases, as has been accepted and argued up and down the country for decades, that is how you approach justification. So you put all of those factors into the mix. And if Mr. Linden were right, he would now be saying that you leave out of account and can't even at the particular disadvantage stage rely on the differential distribution as between advantaged and disadvantaged. And then can I just address Enderby?
Is this your note?
It's still part of the same point, but the others are going to be much shorter. I do need to address Enderby because it's important to emphasise, it's at tab 7 of the bundle, page 162 is where Mr. Linden took you to. And he said this supports his position that what you have to do is look at pay differences. But at paragraph 7, which is the passage he relied on, paragraph 19, the passage he relied on, he says the court was emphasising that the statistics disclose an appreciable difference in pay between two jobs of equal value, one of which is carried out almost exclusively by women and predominantly by men. It's not the appreciable difference in pay that is the reason why there was discrimination in this case. There would have been nothing wrong with paying speech therapists less than the other categories of job, but for what follows, and it's the fact that there was differential between the proportions of men and women, that's what made it discrimination in this case. And you can see that because the appreciable difference in pay just comes from the fact that there were lower pay scales. It doesn't come from an analysis of average pay as between the different job groups. See the head note and see also page 132, the statement of the facts. And so all Enderby does is reinforce the proposition that in all of these cases, what is being looked at the particular disadvantage stage is the disparate impact in relation to the advantaged and disadvantaged groups in a conventional binary division case. In our case, you have to analyse it with a degree more sophistication because of the system that the respondent has chosen to apply. And I won't take you back to it, but Villalba doesn't advance the point any further because it doesn't address this question at all. And Naeem doesn't advance it further because the point wasn't an issue. Because on the statistics, the 3 or 5% threshold was met. So it wasn't an issue in Naeem. 2 very short points to conclude. Point 9, Mr. Linden says we must be wrong because if you take a £100 difference, then within a longer pay band you're less likely to succeed than within a shorter pay band. That's a bootstraps argument. That's starting with the absolute value of the difference being the important thing, and saying because it produces a different result within different lengths of pay band, that shows that we're wrong. But actually, £100 average difference within a longer pay band is going to reflect a less significant differential distribution, and vice versa. So the point is simply an iteration of the fact that this is a choice between two different things. And lastly, in relation to our alternative case on variable pay and the statistics in paragraph 65.1 of our skeleton argument, Mr. Linden is right in his analysis of why those statistics work as they do, but again, I ask rhetorically, why is any of that surprising? If what you're measuring is whether women are more likely to be lower down the scale than men, then it's not surprising that as the scales narrow and the differences become smaller, if women are still clustered at the bottom, the percentage differences may become bigger. But what you're measuring when you're looking at those differences in average variable pay very clearly is of the bit that length of service can affect, men have got how much more. So, my lords, those were my 10 points in reply, but
Well done for counting correctly.
would have been a little bit embarrassing in a case where we've been arguing about maths for a day and a half if I couldn't have counted to 10 at the end. Yeah. My lords, yes. Ms. Priddle reminds me we've got copies of Ches in the RLRs. We've also got copies of an actual pay award. So
that would be helpful.
Consider that.
While you're just handing those out. Can I thank you, you both, also those behind you, juniors and solicitors and complete teams. You're about to.
No, I'm
you're
just
standing up to be
courtesy.
complimented, or you want to give us another document?
No, just courtesy.
Oh.
I can sit down again if you like. I wasn't going to say it.
Strongly invited. For the help we've had. These are issues about which we'll want to think carefully. We will, of course, therefore be reserving our judgments. They will be circulated in the usual way in draft for correction of typographical and other minor factual errors, and also so that the parties can, if possible, agree the terms of a consequential order, or if that's not possible, prepare written submissions so that we can make a decision on the papers at the time of hand-down. Parties need not attend the hand-down. Thank you all very much.
Well, guys.